Joining us on the program right now, Steve Holbrook, Second Amendment attorney and scholar. And Steve, thank you again, sir, for coming on the program.
Oh, good evening, Cam. How are you?
I'm good. It seems like it was just a couple of days ago that we were discussing a case out of Maryland, and today we learned that the Supreme Court is not going to hear this case involving a challenge to Maryland's concealed carry laws. What can you tell us, Steve?
Well, the first Monday in the new term of the court, it happens every year, the same old, same old. There's a real long list of cases that they deny cert in. That means they won't hear those cases. There's so many who are knocking at the door. And the case of Charles Williams versus Maryland was one of those cases. They accepted cert in a few cases, none of them relevant to our issue. But this is one of many cases where the courts throughout the country are holding that there's no right to bear arms. And in this particular case, the defendant Williams was convicted under a Maryland statute that basically says there's, other than limited exceptions, there's no opportunity that a person has to carry a handgun between one place and another. Now, there's another case pending in the Supreme Court, the Maxion Darrow case arising out of the Fourth Circuit. In some ways, much like this case, the court actually in that case followed the Maryland decision and said if the Supreme Court wants us to recognize a right to bear arms, they'll have to tell us directly. They'll have to make us do it, basically. Now, that case is still being briefed. I don't know whether cert will be granted in it because it's a fairly limited scope in which the ban applies there. It's a ban on carrying basically accessible or loaded handgun in certain federal parts, which raises other issues like what places can guns be banned, whereas the Maryland case involved a general ban on carrying handguns everywhere. So these cases are breaking out all over the country. It's really hard to say if and when the Supreme Court's going to take a case on that issue.
I was going to say one of the things that I think helps the Supreme Court along is if there is a split in the circuits. Have we gotten to a point, Steve, where you now have appellate courts having ruled on these cases so that there is a split?
Well, there's been courts have held for centuries now. Actually, the state courts have held for centuries that the right to bear arms means to carry arms. There's no definitive split in the circuits on one specific law. There's no really outlandish split in the circuits on the issue before us, other than the fact that courts have taken different approaches over time. In the very near past, courts are saying, "Oh no, there's no right," because just go back 2 or 3 years, and they said there's no right to keep and bear arms of any kind by any person, and it's a collective right. So it's hard for them to get used to recognizing this right. So there is a very interesting case pending in the Supreme Court. We, NRA, will be filing an amicus brief in that case. It'll be argued in December, and it's called Messerschmitt versus Millender. And that's a case where in California, a general warrant was issued. A general warrant basically says you don't have to particularly describe the things that you have probable cause to be seized.
Mm-hmm.
That was a case involving one bad guy and one bad gun that the police knew exactly what it was. They didn't know where he was, but he used to live with his foster mother. And so they got a general warrant to say seize every firearm on the premises, no matter who they belong to or what they look like. The cops even had a picture of the gun that was in question. The defendant used it to assault his girlfriend. And we see these kind of warrants all over the place. So what happens? He's not even there when they come in with a SWAT team in the dark and before sunup. They throw the occupants out with an old lady in her 70s, a daughter and a grandson, and other occupants. They sweep through the house and they seize the elderly lady's shotgun and her ammunition. And so a civil rights action was filed suing the officers for damages under the Civil Rights Act. It's exactly the kind of thing the Civil Rights Act was intended to allow.
Yeah.
And the U.S. Court of Appeals from the Ninth Circuit said she's got an action there, and it should go forward. And so that's what's at issue. The officers who got this warrant, we see this a lot where police or ATF agents, they get these warrants when there's only one gun at issue, and they want to seize all the guns they encounter, and they're not even at the right house necessarily. So that's what's at issue here, whether her civil rights action will be upheld.
And the Supreme Court is going to hear that case?
Yes, it's already in the briefing stage. Our amicus brief is due later this month, and the oral argument is in December.
Okay. Now, Steve, just before we let you go here, do you think at some point the Supreme Court is going to have to take a right to carry case? I know there's no science in figuring out what the justices are going to do, but at some point, do you think that they'll need to hear a right to carry case?
Well, they'll never have to do anything they don't want to do, and let's don't forget it took them until the year 2008 to ever take a definitive Second Amendment case in the first place.
Yeah.
So I certainly cannot predict anything, but I can tell you this issue is just coming up out the kazoo all over the country. And, and it's coming up, of course, mostly in bad jurisdictions. I mean, most states in this country, due to NRA's efforts, have shall issue carry permits. And we don't have these kind of definitive bans, but they come up in states like Maryland, New Jersey. There's several cases in California right now. Peru is one of them for the Ninth Circuit. New York State. I mean, most states aren't like that. Their rights recognized in most states. So, did I forget to say Massachusetts?
Yeah, I think you did, actually.
We don't leave anybody out. I can't predict that. It could be the court this term would take on a case, although they're really busy this time. They've got Obamacare and a lot of other really big issues.
Mm-hmm.
And whether they want to stir this pot or not, it's hard to say.
All right. Well, listen, Steve, glad you could be with us on the program this evening, sir. Thank you again, and look forward to talking to you again very soon.
My pleasure. Thank you, Ken. Bye-bye.
Thank you. Steve Holbrook, Second Amendment attorney and scholar.